Welcome back to the Lawyer Talk channel of BLawyers Vietnam Law Firm. It is nice to be part on new podcast today. The topic of this podcast will concentrate on legal issue of evidence and proof in civil proceedings at court and arbitration. This is a very important issue in any dispute between civil and commercial areas. About the subject matter of this podcast, we would like to invite everyone to join us in listening to Mr. Tran Ngoc Thuyet, a lawyer and senior partner of BLawyers Vietnam.
Christine, Mr. Tinh, an esteemed listener of BLawyers Vietnam podcast program.
Hi, Mr. Thuyet. May you provide us with a general overview about the importance of evidence and proof in legal proceedings under Vietnamese law?
Under the fundamental principle of Vietnamese procedural law, to prove just lawsuit requests are the well-founded and legal for the court to accept the case. The plaintiff must submit, along with the lawsuit petition, the necessary document and evidence according to regulation. In Article 6 of Civil Procedure Code 2015, regulation on the supply of evidence and proof in civil procedure are as follows. The party had a right and obligation to proactively collect and hand over evidence to the court and to prove that their requests are grounded and lawful. An agency, organization, or individual just initiate a lawsuit or file a request to protect the lawful right and interests of another person, have the right and obligation to collect and supply evidence and proof as through it, he, she, is a party. The second, the court shall assist the party in the collection of evidence and shall only collect and verify evidence in the case prescribed by the Civil Procedure Code. The party has an equal right and obligation when participating in proceedings. They are required to provide documents and evidence to prove and protect their legal right and interest. The party requesting the court to protect their right and legitimate interest must gather, provide, and submit to the court document and evidence to demonstrate that such requests are justified and lawful. A party that protects against another person's claim against him, her, it shall make a written protect and collect, supply and hand over to the court document and evidence to prove his her protect. An agency, organization, or individual that initiate a lawsuit to protect public interest or state interest or request the court to protect another person's law right and interact, shall collect, supply, and hand over to the court document and evidence to prove trust is his her lawsuit or request is grounded and lawful. A social organization participating in protecting consumer interests does not have the burden to prove the fault of a goods trader or service provider under the law of protection of consumer interest. If the party just had the burden of proof failed to produce any evidence or produce insufficient evidence, the court shall set on the civil case or matter based on the collected evidence available in the case or master file.
How is the evidence defined in Vietnamese law and how it is collected?
According to the Vietnamese Current Civil Procedure Code 2015, the definition of evidence is as follows. Evidence in a civil case or the matter is any matter of fact, just a hand over or produced to the court by the party, agency, organization, or other individual during the litigation process, or which is collected by the court according to the order and procedure prescribed by the civil procedure court and is used by the court as a basis for ascertaining objective detail of the case, as well as whether or not the party claim or protect other grounds and lawful. Under the law, the evidence may be collected from the following sources. The first, readable, auditable, or visible material electronic data. Second, material evidence. The third, a party testimony. Four, a witness testimony. An expert witness conclusion on the side appraisal result record, a property valuation, and price appraisal result. Document recording event or legal acts made by a person with official function. Notarized or certified document and other sources as prescribed by law.
Does the law stipulate the requirement and condition for recognizing evidence as lawful?
Procedural do not have specific regulation on what evidence illegal or illegal. However, under the Article 95 of the Civil Procedure Code 2015, the identification of evidence is as follows. The first, readable material shall be regarded as evidence if they are the original or the lawful notarized or certified copy or are the supplied and certified by a competent agency or organization. The second, audible and visible material shall be regarded as evidence if they are the produced together with a document of the processor of such material describing the origin of the material if the processor himself or herself perform the audio or video recording or with a document containing certification by the supplier of the origin of such material or with a document on the audio or video recorder event. The third, electronic data messages are expressed in the form of the exchange of electronic data, electronic document, email, telegraph, telex, faxes, and other similar forms prescribed by the law on illicit transaction. The four, to be regarded as evidence, material evidence must be an original objective related to the civil case or matter. The fifth, a party or witness testimony shall be regarded as evidence if it is recorded in writing or on an audio tape or disc, a video tape or disc, or another device storing sound and image as described in the Clause 2 of the article, or is given orally at a court hearing. 6. The expert witness conclusion shall be regarded as evidence if the expert assessment has been performed strictly according to the procedure prescribed by law. The seventh, an on-site appraisal minutes shall be regarded as evidence if the appraisal has been conducted strictly according to the procedure prescribed by law. As Property valuation and present result shall be regarded as evidence if the valuation of present has been conducted strictly according to the procedure prescribed by law. 9. A document recording event or legal act made by a person with official function shall be regarded as evidence if such document has been established strictly according to the procedure prescribed by law. 10. A notarized or certified document shall be regarded as evidence if the notarization or certification has been performed according to the procedure prescribed by law. Finally, 11. Other shocks as prescribed by law shall be regarded as evidence according to the condition and procedure prescribed by law. As mentioned above, procedural law does not have specific regulation on what's evident illegal or illegal. However, draw the provision in Article 95 of the Civil Procedure Code 2015 on identifying evidence, we can understand that for evidence to be considered valid and accepted by the authority, the evidence must comply with the above regulation on identifying evidence.
By method sharing, we can determine source of evidence as well as legal regulation on determining the legality of evidence. So, according to the law, are there any exceptions where evidence is automatically recognized as legal?
The law on proceedings stipulates some exceptional case in Article 92 of the Civil Procedure Code 2015. Accordingly, the following detail and facts are not required to be proved. Detail and facts just are clear and known by everyone and are accepted by the court. Detail and facts just have been confirmed in a court legally effective judgment or decision or a legally effective decision of a competent state agency. Detail and facts just had been recorded in lawful notarized or certified document. If adopting the objectively appropriate detail and facts or the notarized or certified document, judges may ask the party notarizing or certifying agency or organization to produce the master or original document. If the one party admits or does not object to detailed facts, material, document, or conclusion of the professional agency which are presented by the other party shall not be required to prove them. When a party had a representative participating in the legal proceeding, the acknowledgement by the representative is considered the knowledge of the party, provided just it does not exist the scope of representation. Accordingly to, if a party had a representative participating in the proceeding, such representative admission shall be regarded as the admission of such party, provided that such admission does not fall beyond the scope of the presentation. Therefore, when a party authorizes an individual or organization to represent them in legal proceeding, it is necessary to clearly define the scope and content of the authorization.
So when individual and organization submit a petition to a competent dispute settlement agency, how should they prepare the attachment evidence?
Yeah. Uh, AI previously stated evidence is regulated in several sorts, depending on the type of the evidence prepared by the petition owner. The petition owner should ensure the legality of such evidence by law. When filing a petition, a lawsuit petition shall be accompanied by document and evidence proving the lawful right and interest of the petitioner just as the imprint upon. If for an objective reason the petitioner cannot submit adequate document and evidence together with the petition, the petitioner shall submit available document and evidence to prove that the petitioner lawful right and interest are the infringed upon. The petitioner shall supplement the petitioner document and evidence or at the other document and evidence a request by the court during the session of the case.
It is correct that the plaintiff is exercising their right and responsibility to prove their case in the court, and how is this application regulated according to the law?
Just is correct. As I mentioned earlier, specifically, the obligation to prove is regulated as follows. The litigant who request the court to protect their legitimate right and interest must collect, provide, and submit to the court document and evidence to prove just their request is based on the legal and legitimate ground. The litigant who objects to the request of another person must express it in writing and must collect, provide, and submit to the court document and evidence to prove their objection. The agency, organization, or individual who initiate the lawsuit to protect public interest, the interest of the state, or request to the court to protect the legal right and interest of others must collect, provide, and submit to the court document and evidence to prove their lawsuits or request either based on the legal and legitimate ground. The litigant must present evidence to do their case. If they cannot present evidence or do not present sufficient evidence, the court will resolve the civil case based on the evidence collected in the case file.
Are there any cases where the litigant will not need to fulfill the obligation of proof as stated?
Yes, there are four cases where the litigant is not required to prove their case. The first, consumers do not have the burden to prove the fault of a goods trader or service provider. In this case, the goods trader or service provider has the burden to prove she is not at fault for causing the damage. The second, the litigant being an employee in a labor case cannot supply and hand over to the court document and evidence because such document and evidence are the managed and kept by her employer. In this case, the employer is required to supply and hand over such document and evidence to the court. The third, if the employee sue against the unilateral termination of her labor contract in the case in which the employer either prohibited by the labor law from unilaterally terminating certain labor contract or from disciplining the employee, the burden of proof rests on the employer. And finally, fourth, social organization participating in the protecting the right of the consumer are not required to prove the fault of the organization or individual engaged in the good and service business.
If the litigant is unable to submit evidence because they are unable to collect it by themselves, can they request the competent authority assistance to collect the evidence?
The answer is yes. According to the Civil Procedure Code, if the failing to collect document and evidence after having taken all necessary measure, a party may request the court to issue a decision to request an agency, organization, or individual just either keeping or managing document and evidence to supply them, or they may request the court to collect document and evidence to ensure the proper settlement of the civil case or matter. A party just requests to the court to collect document and evidence shall make a written request clearly stating the matter to be proved, the document and evidence to be collected, the reason why she is either unable to collect document and evidence, and the full name and address of the individual or the name and address of the agency or organization with a managing and a keeping such document and evidence.
The information on evidence and proof in court proceeding is very useful and necessary for those who are concerned with providing evidence and fulfilling the burden of proof when disputes arise in the civil sector. In addition, commercial arbitration is also very common among dispute settlement agencies. Could you share the burden of proof and provide evidence in commercial arbitration proceeding?
Similar to court litigation and international arbitration proceeding, the law on commercial arbitration breaks just the claimant and the respondent had both a right and obligation to provide evidence to the arbitral tribunal in supporting their claim and prove just the facts relevant to the issue under dispute are the well grounded. However, the disputing party often consider that the arbitral tribunal either obliged to collect evidence at their request to resolve the case. Therefore, the practice of the setting dispute at some arbitration center in Vietnam shall just the party has not actively collected evidence to prove their claim, but request the appeal tribunal to do so. It should be noted that there has been decay in practice. The claimant initiated an application but failed to provide evidence to support its claim from the time of the case acceptance until the day of opening the final settlement meeting. At the final settlement meeting, the claimant requests an extension of the time to provide evidence, but the arbitral tribunal refused the claimant request and issued an award not to accept the claimant claim. After that, the claimant requested the court to annul the arbitral award on the ground that the arbitral tribunal violated the basic principle of Vietnamese law when refused its request for extending the time of proving evidence. Finally, the competent court stated that the arbitral tribunal did not violate the Vietnamese law basis principle in this case and refuse the claimant request for annulling arbitral award. Which means we are referred to the decision, the number 12, 2018, day 9 November 2018 of the Hanoi City People Court.
Do the party have an obligation to provide evidence upon request by the arbitration tribunal?
The current law on commercial arbitration 2010 had not stipulated the right of the arbitral tribunal to request the dispute party to provide evidence. However, regarding the issue, the arbitration rule of Vietnam International Arbitration Center VIAC regulates that the arbitral tribunal shall have the power to request the disputing party to provide evidence, and the party shall be obligated to provide evidence accordingly.
Could you explain how the arbitration tribunal can verify and collect evidence?
The first, the jurisdiction of the Arbitration Council to verify master. In the process of dispute settlement, the Arbitration Council had the right to meet or exchange with the party involved in the dispute, with the presence of the other party in appropriate form to clarify issues related to the dispute. The Arbitration Council may investigate the matter from the third party with the presence of the party or after notify the party. The jurisdiction of the Arbitration Council to collect evidence. If the Arbitration Council or one or more party have applied necessary measures to collect evidence but still cannot collect it themselves, they may send a written request to the competent court to request the agency, organization, or individual to provide documents just can be read, heard, seen, or other relevant objects related to the dispute. The request must clearly state the content of the dispute being resolved at the arbitration. The evidence just needs to be collected. The reason is cannot be collected, and the name and address of the agency, organization, or individual managing and preserve the evidence just need to be collected. Within 7 working days from the day of receiving the written request for evidence collection, the president of the competent court shall assign a judge to consider and resolve the request for evidence collection. Within the 5 working days from the day of assignment, the judge must have a written request for the agency, organization, or individual managing and preserving the evidence to provide the evidence to the court or the same judge document to the same level procuracy to perform the function and attack as prescribed by law. Agency, organization, and individuals who are managing and preserving evidence have a responsibility to provide complete and timely evidence upon request by the court within 15 days from the day of receiving the request. Within the 5 working days from the day of receiving the evidence provided by the agency, organization, or individual, the court must notify the Arbitration Council and requesting the party to proceed with the exchange of evidence. In case the RNC organization or individual formed to provide the request evidence within the prescribed time limit. The court must immediately notify the arbitration counsel and the requesting party, and at the same time issue a written request to the competing agency or organization to handle it accordingly to the provision of the law. Also, the party just request the collection of evidence or summon of the witness must pay the fee and the court thereof. If the arbitral tribunal requests the court to collect evidence or summon witness, the fee and cost shall be paid by the party that request the arbitral tribunal. In practice, the application of the above regulation may face several difficulties as follows. The arbitral tribunal has non-state jurisdiction and constitutional power. Thus, the witness often do not provide evidence or document or attend the meeting session for settling the dispute a request by the arbitral tribunal. The second, the assessment and valuation of the access either the arbitral tribunal obligation or under the discretion of the arbitral tribunal with enough clear understood and expert evidence is rarely used in Vietnam arbitration proceeding due to the lack of comprehensive regulation for expert evidence.
Very much for your sharing today. Dear listeners, this podcast episode of the Lawyer Talk is ending now. Thank you for your attention and see you again in the upcoming podcast. Please leave your comment below if you have any questions or concerns. For more information about BLawyers Vietnam, please visit our website with a link below. See you soon.